Hey, greetings. Welcome back to Categorical Imperatives. I am Lockie and Liberal, as always. For those of you who are already familiar with the show, I really hope that you will enjoy this new and improved version that I'm bringing to you here over on the YouTubes now. I've had a chance to upgrade some of my sound equipment, so the charming and witty narration I have and the smooth, dulcet tones of my voice that I know you all just love so much should sound that much better. That's a gift for you. You're welcome. Also, obviously, you will see that I have this new visual element that I've been able to bring into the show a little bit, not just doing pure audio. So I hope you guys like that. I've got some big plans for that, actually. I think it's going to make for a much more interesting show in the long run. I know it'll at least be more interesting for me to make. If it's more interesting for you to watch, great. Otherwise, who the fuck cares? If this is, sorry. If this is your first time tuning in, let me welcome you to the show. Uh, this is a podcast where we use legal and moral philosophy to discuss current events surrounding politics and culture, especially in places where I think my sort of interest in constitutional law and American jurisprudence can provide a interesting or unique perspective to a particular topic. Today, we are going to be examining what I think is such a topic. We are going to be talking about gun control as it pertains to constitutional law. This is because this issue has really become much more heated recently in the country than at any time in the past that I can recall. And not the least of which would be the big uh, hubbub that was going on out in Virginia not that long ago. So people even talking about it being the boogaloo. Obviously, that didn't happen, which is fantastic. But yeah, it's getting to be a very important issue to try and find some clarity on. So I have an article here from the Washington Post. It's actually not a new article. I've been hanging on to this for a while. I've been waiting for the right time to use it, and I think this is that right time. And what I think we are going to be able to do today is go through this article together and try and work out how it is exactly that in this country we have our understanding of what the Second Amendment means has become so radically obfuscated. So this will be the first of probably 3 segments covering this article. It's a long article, and as you'll see, I really kind of get into the weeds here on a lot of the history with it. So it'll be in depth, but I think it'll really be worth it. Hopefully, you guys enjoy it. So, today will be part one, and then at the end of the show, if it sounds like it's any kind of awkwardly or without any resolution, that's only because it is. Uh, so that's that. But, anyways, what are we going to do precisely? We are going to be examining the two common interpretations that are commonly held about the Second Amendment in our country today. Namely, is it a collective right of state militias, or is it an individual right to self defense not necessarily connected with militia service? We are going to examine those, and we are going to see if we can possibly parse out the most constitutionally sound one.
All right, we're done.
You think the language in the Second Amendment is clear enough? You know, about the right to bear arms?
Of course it's clear. Every American has the right to hang a pair of bear arms on their wall. How could that possibly be misconstrued?
All right, with that, let's just get right into the article. So it starts out, love it or hate it, the Second Amendment provides a constitutional framework for American gun laws. As with all things constitutional, Americans are adapting 18th century laws to fit 21st century lives. But in reality, the concerns of the founding fathers had little to do with either side's position in the modern gun control debate. None of the issues animating that debate, from stand your ground laws to assault weapons bans, entered into the founders' thinking. Yet, because both sides in the debate about the Second Amendment evoke what the founders would have thought, it is important to look at what they actually intended. So, right off the bat, there's a couple red herrings with this article. The first one is his notion that he says the Constitution provides or the Second Amendment provides the constitutional framework for America's gun laws, and that is a statement that misses the mark almost entirely. As you can see, I have this quote that is at least purported to have once been said by Patrick Henry, that the Constitution is not an instrument for the government to restrain the people. It is an instrument for the people to restrain the government. Another way to look at the same idea is the description that is constantly used by constitutional law scholar Randy Barnett. I don't know if you guys are anything like me, by which I mean a legal theory wonk with a JD and no social life. I'm sure you also have your own enthusiastic personal favorite con law scholar. So, at the risk of incurring hate mail and death threats from all the Akil Lamar and Bruce Ackerman fans out there, I'm just going to go ahead and say that I consider Randy Barnett our greatest living constitutional law scholar. He has all the wit of St. George Tucker, plus the charming, handsome looks of a Thomas Cooley. Uh, but what Barnett has to say about the Constitution is this: the Constitution is not the law that governs us. The Constitution is the law that governs those who govern us. So, in relation to this article, uh, you could technically say that our author is correct when he says that the Second Amendment has nothing to do with either stand your ground laws or bans on imaginary classes of weapons. But the reason it has nothing to do with those things is because the Second Amendment cannot, in any sense whatsoever, possibly be considered a constitutional framework for American gun laws. And this is uh, really a central theme, not just to this episode, but to this show in general. Something I cannot stress strongly enough. When talking about the Constitution, nothing in the Constitution should ever be so construed as to grant any power or place any limit on any citizen. What it does is it creates the federal government, it gives the federal government expressly delegated powers, and it puts limits on the federal government. That is the purpose of the Constitution. That is all it was meant to do. So, uh, really, the main purpose of this video today, or this section that we will be doing, is correcting the impression that the author has already begun to present, and that is that the reason that we disagree about the meaning of the Second Amendment is because these two different opinions that we hold are both being reasoned out by people who are trying to interpret the founder's intent. And one side has interpreted their intent correctly, the other side has interpreted it incorrectly. But this simply is not so. The reason that we have such different views of what the Second Amendment means is because we are reaching them using two very different means of constitutional interpretation. There is original intent. Really, though he doesn't say this outright, original intent is the mode of interpretation that is being used in this article by this author, is sort of by proxy, not so much directly. And then on the flip side, I will be presenting what is known as the original public meaning methodology. Now, it's not that either of these methods of interpretation are the only means of constitutional interpretation. They absolutely are not. They're not even necessarily the only means of interpreting the Second Amendment. But when we're trying to figure out how did we get to this place where we're at today, where one side says that the Second Amendment is a collective right of state militias, the other side says it is an individual right to keep and carry arms for self-defense, uh, to understand where these two different theories come from, you need to understand original intent and original meaning, respectively. So let's define our terms real quick. Original intent maintains that in interpreting a text, a court should determine what the authors of the text were trying to achieve and to give effect to what they intended the statute to accomplish. The actual text of the legislation notwithstanding, as in purposivism, tools such as legislative history are often used. On the other hand, original meaning, which is sometimes also known as original public meaning, is defined as how a reasonably intelligent and evolved member of the public would have interpreted a provision at the time of its drafting, relying on the primary evidence of original meaning based on how words were used in common discourse and the definition of the words that we can find in contemporaneous sources, such as dictionaries and legal sources. And while circumstantial evidence can play a small role, such as notes from drafting and ratification conventions, that should not be the crux of original meaning. If anything, that is really just something that can be used to um, accentuate the more direct evidence that original meaning is looking for. All right. And next, there are a couple flaws that even someone making a good faith argument for original intent tend to fall into sort of logistical flaws. And our author in this article falls into all of them several times. And so, what I want to do is I wanted to go through those with you together and just explain what they are real quick. So, as they come up and as I'm pointing them out, you'll be able to understand what I'm referencing and what exactly I'm talking about. So the first flaw of original intent is something that I've come to refer to as anachronistic legal interpretation. Anachronistic legal interpretation is when an argument is made by clearly beginning with a biased assumption that the intent of the framers must be the same as the outcome the person making the argument would prefer, and that they then work backwards to find evidence that reaches their conclusion rather than reaching a conclusion from the evidence. Next is something that I refer to as original misintent, and this is essentially when you make an argument that at best only ever really conveys an example of what something does not mean without providing any substantive information about what it does mean. We've already seen a very good example of this in this article. A good example is the point that he made a little bit ago, that a ban on the imaginary class of weapons that he refers to as assault weapons, that I, for brevity's sake, will refer to by their official designation of modern sporting rifles. Even if it could be proven that modern sporting rifles lie outside the Founders' Second Amendment, that's still really ultimately irrelevant because all that has really done is told us one thing the Second Amendment supposedly is not, without any substantive comparison of what it is. The next issue is really sort of a framing device that people use. I call this motivational originalism. And what this means is that with original meaning or original public meaning, uh, the method of interpretation should be functional, whereas with original intent, the method of interpretation is motivational. It relies on the private motive of the framers or the founders, which are really, by any objective standards, irrelevant and largely unknowable, and are likely to have been diverse. These are all different individuals with individual thoughts and beliefs. So the common law rule of interpretation, understood by the founders, was merely to discern the functional role of the elements of the law, not the private purpose of the lawgivers. And finally, the last little flaw I want to mention is something that I refer to as incidentalist legal interpretation. Now, incidentalist legal interpretation is, in a sense, it is when you put forward an argument that whether or not it's true is irrelevant to the question at hand. This can be difficult to pick up on because an incidentalist interpretation may, even sometimes with cursory scrutiny, seem relevant when it's actually not. Now, actually, the author's first point is a great example of what I mean by incidentalism. So let's move on to the next part of the article, and I can use that to kind of help clarify. Point one: the founding fathers were devoted to the militia. Read the debates about the Constitution and the Bill of Rights, and the militia's importance leaps off the page. Alexander Hamilton, writing in the Federalist Papers, called a well regulated militia the most natural defense of a free country, and his anti Federalist critics agreed with the need for a citizens' militia, writing that a well regulated militia, composed of the yeomanry of the country, have ever been considered as the bulwark of a free people. Their disagreement was over how to best ensure that the militia was maintained, as well as how to divide up the roles of the national government versus the state government. But both sides were devoted to the idea that all citizens should be part time soldiers because both sides believed that a standing army was an existential threat to the ideas of the revolution. So, what makes that paragraph an example of incidentalism? Uh, it's that while it is true that the founding fathers generally saw the role of the militia to our nation as exceptionally important, that it does not follow from that at all that the second paragraph is necessarily true. He has not given us any reason to think that because it was important that they were then in disagreement over how to best divide up the militia between the national and state governments. It's one thing to incidentally understand that the militia was important to the founders, uh, but how valuable is an understanding of the militia? Uh, how valuable is an understanding that the militia was important to the founders if it is demonstrably true that your understanding of what the militia actually was and why it was important and how they went on to protect it is objectively incorrect. And he really fails on all three of those sort of hypothetical follow ups. Now, I can only speculate because he never really clarifies at any point in this article what he means by the term militia. Because his argument seems to really rely on an oblique, non-committal concept that appears to be crafted to avoid falsifiability. That's how I read it, at least. I could be mistaken. Um, but I, I, I get, and again, I don't like to ascribe motive to other people, but uh, I get the feeling that his uh, official definition of what he believes a militia to be is rooted so strongly in his anachronistic prejudices and preconceptions that he is assuming that his truth, and I say truth with a small t, is inseparable from the truth with a big T, and that he does not need to define the militia because it is what he thinks it is, and it therefore goes without saying. So, uh, let us clarify exactly what the term militia does mean. And if we want to find out what the term militia meant to the framers, as original public meaning would dictate we do, a good place to look for a definition is a statute or a series of statutes, technically, that were known as the Militia Acts of 1792. The Militia Acts of 1792 say that the militia, it is a voluntary military force distinct from a standing army and under law and custom were composed of two distinct classes, the organized militia and the unorganized militia, which were also often referred to as the select militia and the general militia respectively. Now, when most people today think of the term well-regulated militia, what they are thinking of in their mind is the select militia, which is only half of the militia, really as a whole. And I guess the best way to sum up the select militia would be any formal, regimented, voluntary militia force that is expected to show up at appointed times with arms for inspection and drilling and training. Now, this confusion is understandable given the meaning of the term well regulated within the parlance of our own times. But the original meaning interpretation requires that we go back to dictionaries and legal treatises and statutory definitions from around the time of the drafting of the Constitution. And when we go back there, every definition we find for the term well regulated is not at all what most people would expect. So, again, I think an anachronistic interpretation of what well regulated might mean to someone nowadays would be something to the effect of a something that is tightly controlled or carefully governed according to strict rules or guidelines. But that's really not the historical definition that we find from the time period. All the historical definitions that we find from that time simply defined it as something that is in regular working order. So, in this instance, all it is talking about are people with well functioning arms who are familiar with their handling and capable of handling them. Is that simple? And we will come back a bit to this in a little bit, but before we get too off track, I do want to also define general militia. Now, general militia, and this is at the time of the founding, from the Militia Act of 1792. The general militia is defined as all free, able bodied males capable of bearing arms, not already enlisted in the standing army or a select militia. So, another point here to keep in mind as well when we're talking about all of this is it is important to bear in mind the time difference between the constitutional ratification and the Bill of Rights ratification. These are separated by nearly 4 years. And the reason this is important because these were issues that were animated by very different topics of debate and different perceived needs. So, really, when he talks about the importance of the militia, he's absolutely right that the importance of the general militia was something the founders were really devoted to. There really is a wide agreement among the cross section of varied opinions that you find from the founding generation that a general militia was an ideal that they were deeply devoted to. And this is precisely what the prefatory clause of the Second Amendment speaks to. Now, it's the next leap he makes that makes the truth of the first paragraph of his point an example of incidentalism. There is no logic at all in the conclusion that because the prefatory clause indeed states the importance of a general militia, that either the intent of the prefatory clause, much less the meaning of the operative clause of the Second Amendment, had anything to do with dividing up the role of the militia between the state and federal government. And it's this second paragraph that demonstrates why it is important to distinguish between the time frame of the constitutional debates and the Bill of Rights debates. Because, and technically, how to divide up the role of the militia, in all fairness, was indeed a hotly debated issue. However, this was a debate that ended in 1787 with the final draft of the Constitution that came out of the Philadelphia Convention. So, specifically, it is the section in our Constitution that makes up what is known as the Congressional War Powers. This is under Article 1, Section 8, which is what grants all congressional powers. And in Article 1, Section 8, clauses 11 through 16 make up what are known as the Congressional War Powers. And specifically for our purpose here, we are going to be talking about uh, uh, Clause 15 and 16. So, Article 1, Section 8, Clause 15, known as the Militia Clause, says that the militia shall, excuse me, the Congress shall have the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrection, and repel invasion. Next is the Organizing Clause, Article 1, Section 8, Clause 16, that the Congress shall have the power to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the disciplines prescribed by Congress. So, when we take these two clauses together, what we see is that in a very limited number of instances, such as purposes of civil unrest or as a defensive force, the militia would be ready to act to repel such an invasion. Congress may call forth the militia for that limited purpose for as long as they are needed to restore order. His claim as to what the Second Amendment meant really isn't just anachronistically muddled. It also really, when you begin to take it apart, is it's logistically bizarre. I get. Does anyone seriously believe that the purpose of the Bill of Rights, which in every single other clause in the other 9 amendments that make it up, uh, is clearly about preserving the individual liberties of the people from government abuse, corruption, and tyranny? But somehow, when it comes to the Second Amendment, it is unique in protecting the right of a state and a federal government to divide up their militia forces. Does anybody really think that that's what the disagreement was about? So, what we have is the Anti-Federalists were worried that because of the way that these militia clauses in the Constitution that we just went over, because of the way that they were worded, that it may be possible in the future for a corrupt Congress to misrepresent the militia clauses as creating a select militia. They worried that this could be used as a means of disarming citizens except those who are actively serving in the select militia. Now, this is summed up beautifully in a letter by Richard Henry Lee under the pen name Letters from a Federal Farmer. And what he said was, whereas to preserve liberty, it is essential that the whole body of the people always possess arms and be taught alike, especially when young, how to use them. Nor does it follow from this that all promiscuously must go into actual service on every occasion. The mind that aims at a select militia must be influenced by a truly anti-republican principle. And when we see many men disposed to practice upon it, wherever they can prevail, it is no wonder the true Republicans are for carefully guarding against it. So, on the other hand, uh, the argument that was made by the Federalists about this, in reply to the argument that was made by people like Richard Henry Lee, was to say essentially that there is no way a free nation would ever be so foolish as to believe that the Constitution of a free peoples would create a select militia as a check against government tyranny. Furthermore, they would argue that there was no need to specifically protect the people's individual right to keep and bear arms because there is no power anywhere granted in the Constitution that gave the government the power to disarm the citizens under any pretense to begin with. And this is the heart of federalism right here, that our national government is a limited government. Its powers are few and defined. Um, and in fact, this is what the final amendment in the Bill of Rights is meant to clarify. The 10th Amendment states that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. What this is saying is that if you cannot find a power granted anywhere in the 7 articles that make up the Constitution, that means that power does not exist. Now, if you want to know more about this topic generally, there's an organization that I would like to encourage everyone to check out known as the 10th Amendment Center. They really are a fantastic organization. Their purpose is about teaching people and also advocating for ideas like constitutional originalism. They are a great resource for information on federalism, on our early constitutional law, individual rights, American history, all sorts of good stuff. And I'm not, I'm not affiliated with them in any way. I've been a big fan of their work for many years. I can't say enough great things about them, and so I just wanted to give them a shout out and say that if you want to learn more about them, and I hope you do, I will be putting a link to the 10th Amendment Center's website down in the description of this video. Go check it out when this video is done. You won't be disappointed. But back to our issue at hand. Clearly, the federal government's powers are few and defined. So said the Federalists. Not only do we all understand that the right to bear arms, to self defense, and to resist a government usurping power with force of arms are a birthright of every American, there is nothing in this document that could possibly be seen as granting the government the power to disarm any citizen for any reason. So, if the Second Amendment isn't about the right of the state and federal governments having the right to have a militia, what is it about? Let's get around to clearing that up now. Now, a good place to start to answer this question is a place that almost nobody ever does, and that is with the preamble to the Bill of Rights. Now, a preamble, to be clear, is defined as a clause at the beginning of a constitution or a statute that is explanatory of the reasons for its enactment and the objects sought to be accomplished. So it is not binding law, but it is explanatory in nature. And the preamble to the Bill of Rights reads, the conventions of a number of the states having at the time of their adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added, and as extending the ground of public confidence in the government will best ensure the beneficent start of its institutions. So, the purpose, according to this preamble, the purpose of these amendments that come in the Bill of Rights is to prevent misconstruing or abusing powers by the federal government. And this goes right back to my early point. The Constitution is not the law that governs us. The Constitution is the law that governs those who govern us. So, in this case, under the example of the Bill of Rights, what the preamble tells us is that this is the law that governs those who govern us, specifically through further declaratory and restrictive clauses. So, with that in mind, let's finally look at the Second Amendment itself. The Second Amendment reads, a well regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So when we kind of take this apart, keeping in mind the definition of the preamble, the explanation of what they say the Bill of Rights is meant to do, it says through declaratory and restrictive clauses. So when we read this, we have a well-regulated militia being necessary for the security of a free state. That is a declaratory statement. The right of the people to keep and bear arms shall not be infringed. That is a restrictive clause. So, what the Second Amendment says, uh, according to original meaning is that the militia is important, and because the militia is important, the people have an individual right to keep and bear arms. That just about wraps it up for today. There's one point that I kind of want to make now that isn't necessarily connected directly to this part of the article. But while we are dealing with the prefatory and operative clauses of the Second Amendment and how those fit together, I just kind of want to touch on something that you will hear people who argue for the collective rights interpretation, which are generally also in our day and age, generally the people who will be arguing for gun control, though not always, that just generally speaking, is that they will say that, well, the people who read the Second Amendment as an individual right only read in the second clause and they don't read the first part of the clause. Uh, and that's because if they did, they would see that the only thing that this does is uh, give a collective right of militias. And I want to give an example of why they're kind of right and why they're kind of wrong. Um, they are right in that the first and the second clause of the Second Amendment cannot and should not be seen as completely separate things. One depends upon the other. This is absolutely true. You cannot separate these clauses and have the Constitution, or not have this amendment, I should say, mean the same thing that it means when they are together. But a comparison a lot of people don't think about is the First Amendment. I think a lot of people, unfortunately, aren't really aware that the First Amendment does not protect one right. The First Amendment protects five individual, unique rights. Now, these are first, the Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Two is they shall not prohibit freedom of speech. Three is freedom of the press. Four is the right of people to peaceably assemble. And five is the right of the people to petition their government for redress of grievances. So, what we see here is that, in a sense, all of those different clauses can be read individually. You can appreciate what it means when it says, uh, Congress shall not prohibit a free press. Congress shall not prohibit free speech. Uh, these things can be appreciated individually, but at the same time, when you take them individually, without ever considering them as a collective single amendment, you still change the meaning of the amendment. So while it doesn't change the operative right itself necessarily to look at these as five individual rights, when we kind of look at these together and look at what they're protecting, free speech, free press, free assembly, petition for redress of grievances, what do these things all have in common? These are all means that the people have to voice their concerns with their government, the means that they have to peaceably dissent from their government when they believe their government is wrong. It is their way uh, to peacefully fight back when they see something that they consider abuse, corruption, or tyranny. So, just like the First Amendment has different rights that don't mean the same thing if you take them individually, but all have individual meaning, if that now makes a little more sense to you. Um, I think it's important to see the Second Amendment in the same way. So, when there are people out there, I will be the first to admit this. There are people out there who make the individual rights case and they only bring out the second part of the amendment, and they won't mention the first part of the amendment, and I think that's a mistake. Um, but at the same time, to pretend um, that this that these two clauses can only mean one thing and they must be connected, and because the first clause mentions militia, that the second clause must mean militia, even though it says people, is just as much of a mistake. So, yeah, I'm kind of rambling at this point. Uh, anyways, we are done with the official part of this video for today. I will be back in another day or two, or today's Friday. I'll probably be on Monday sometime posting part two, continuing on with this particular topic and with this article that we have on hand. So until then, this has been Categorical Imperatives. I have been Lacking Liberal, talking about the Second Amendment. Till next time.